It will be travesty of justice if not it is now today contended by Government of India responsibly before this court that no, it has happened. But now governor can send in and we can act on it. Supposing they passed a resolution later saying now we don't want to get out of India and 370 should not apply to us. Was it permissible? In my respectful submission, no. And I respectfully submit that it is impossible to not accede to that interpretation. It was a one-time exercise. Lord, in my respectful submission, the argument that Lord government is advancing before your lordships, Lord, does not bear out from plain reading of the constitutional provision. Now see, Lord, chapter 21, the title, temporary, transitional and special provisions. Now, Lord, I accept that 370 is temporary because it's titled temporary.
Yes.
But it is temporary from the perspective of J&K, not temporary from the perspective of the Indian Dominion or Indian Republic. The choice was left to the Constituent Assembly and therefore the people of J&K to decide whether you want to continue with this status or you want to be away from India. That was the choice. And I will show that note from Mr. Iyengar's, Gopalaswamy Iyengar's note, a very express statement before the Constituent Assembly. So, Lord, he was chairing the committee which drafted Article 370. There were 8 members in it. And they did it because of the extraordinary situation. They realized that we are losing J&K out of our hands. Now you persuade, Lord, citizens of a state, a country, at that time an independent state, to cede to you. They agree to session on clear understanding.
There is a question of persuasion by...
Sorry?
It was the Raja who requested the government of India that time.
I agree. No question about it.
You are
but
saying
the
that
conditions, historical conditions can't be lost sight of. Your lordships are right. Raja requested, but in that letter he expressly asked for this protection. In that letter, he expressly asked for this protection. The Governor General agreed to that. And that is why the Constituent Assembly debated.
That's what Mr. Sibal argued, that after 1954, this 370 has become a permanent
yes.
feature of the Constitution.
Now just see, Lord. Just see, Lord, 370. Lord, 370 is, Lord, what? Lord, first and foremost, 370 is, Lord, that, Lord, Article 371C is most important. That's first. The provisions of Article 1 and of this article shall apply in relation to that state, meaning thereby all other articles will not apply. That's an emphatic statement in the Constitution. Article 371C. You have to begin journey of 370 with that. Then, Lord, they go forward and say in Article, Lord, B, power of Parliament, in Article B2, just a second, an article, Lord, after that in D, such other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. So, Lord, only Article 1 and Article 370 were expressly applied. All other articles were to be applied by the President, subject to this exercise of power under D. And read with the proviso, provided no such order which relates to matters specified in instrument of accession shall be issued except in consultation. So if it is part of instrument of accession, in consultation. If it is outside the instrument of accession, concurrence of the state government. Now, state government here must be understood in the context of democracy. It cannot be understood in the context of 356 and governor exercising omnipotent powers. That's why it is not very important for your lordships to read this in letter and spirit. So, Lord, the constitutional provisions are now added by 1C and 1D. The legislative powers are added by 371A. 1A and specifically B. The power of Parliament to make laws shall be limited. Please see the words. Shall be limited, mandatory, to those matters in Union list and the concurrent list which in consultation with Government of State are declared by President to correspond to matters specified in instrument of accession governing accession of state to the dominion of India as matters with respect to which dominion legislature may make laws for that. And 2, such other matters in the said list as with the concurrence of government of state president may by order specify. Now, my lord, why is it temporary? Please see subarticle 2. Please see subarticle 2. If concurrence of government of state referred to in para 2 of subclause B, that is legislative power of clause 1, or in the second proviso to subclause D of that clause, that's constitutional provisions, be given before Constituent Assembly for the purpose of framing constitution is convened, it shall be placed before such assembly for such decision as it may take thereon. Why? Because not democracy. You could only do it if Constituent Assembly approved it. It was a temporary provision. So the new Constituent Assembly is being now convened, and soon it may mean in the meanwhile, President may exercise powers in consultation with the state government under 1B or 1C or 1D. They said, yes, they can. But you place them before Constituent Assembly for a post facto approval. So it was never intended to be permanent. It is a temporary provision. And the entire burden or entire onus or entire responsibility or entire power decision to make the applicability was left to the Constituent Assembly. This can't be wished away. This is a constitutional provision. President can't exercise powers like this and say 370 is now otiose or it stands repealed or it stands withdrawn. Now in that context, please see Article 3, sub-Article 3. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative. So he can either say it will be cease to be operative, or he can continue, or shall be operative, which means shall be continued, only with such exceptions and modifications and from such date as he may specify. So the power is both for President to continue or President to discontinue. If he wants to continue, he can continue in same fashion or with such exceptions and modification. But for President to do so, prior consent of the Constituent Assembly is a must, provided that the recommendation of Constituent Assembly of the state referred to in clause 2 shall be necessary before President issues such a notification. So Constituent Assembly will send a notification to the President or a resolution, and on that President alone can act. You can't rewrite this. It is not capable of any other understanding. It was therefore an exercise which was limited by an exercise which brought a temporary provision, but temporary in terms of the objects, temporary in terms of the actions to be taken, not by efflux of time. But time becomes important because the life of Constituent Assembly was only till 1957. Now, Constituent Assembly, as your lordships have been told, went into it in Kashmir. They said, we want to be part of India. We want Constitution of India to apply to us. We want Article 370 to continue. President accepted that and issued CO in 1954. End of the matter. Where does he then have power to re-exercise that rule? It will be travesty of justice if not it is now today contended by Government of India responsibly before this court that no, it has happened. But now governor can send in and we can act on it. Well, that will be virtually destroying this very express provision. And I respectfully submit that it is impossible to accede to that interpretation. It was a one-time exercise. It was not intended to be exercised again and again. Even Constituent Assembly was not given power to do it again and again. Supposing they passed a resolution later saying now we don't want to get out of India and 370 should not apply to us. Was it permissible? In my respectful submission, no. So your lordships will have to look at it either way. That's why the word temporary is very meaningful as the heading of the article. So I respectfully submit that this article has lived its life, has achieved its purpose. Now 371 survives because tomorrow a constitution is amended and new article is inserted, which we would like to apply to Jammu and Kashmir also. President then seeks the government's view and then extends the article. So to that limited extent, perhaps this Article 371 may be necessary. But 373 is very clear that applicability of Constitution of India per se was only in terms of Article 373. And once they decide that, then no, it is untouchable. It cannot be revisited. President became functus officio in 1954 so far as 373 is concerned. And your Lordship's Court have expressly accepted this position. Lord, in Premnath and Sampath Kumar, both your Lordships have accepted this interpretation. I'll make it good to your Lordships. Expressly, your Lordships have said that. And that is the view. Now just turn to the view of Gopalaswamy Iyengar.
Mr. Dave, if Article 370 works itself out and achieves its purpose once the Constituent Assembly for the state of Jammu and Kashmir has completed its task, then where was the occasion thereafter to issue constitutional orders post 1957?
That's for 371 to extend from time to time any amendments. Because there were many provisions of constitution which may not have been made applicable, or many laws which may not have been applicable.
But if you see the proviso to D refers to other provisions of the constitution, which will apply subject to such modifications. Then matters which are referable to the IOA require only consultation.
Yes.
All other provisions of the constitution require the
concurrence.
Require the concurrence. That's the second proviso.
Right.
Then the sub-article 2, clause 2 says, if the concurrence has been given before the Constituent Assembly has given its opinion, then it has to be placed before the Constituent Assembly for its opinion and for its concurrence. So your whole argument is that Article 370 has now worked itself out once the Constituent Assembly completed its task. But that would be belied at the least by constitutional practice, because even after 1957, there were orders which were issued, constitutional orders progressively modifying the provisions of the constitution in relation to the state of Jammu and Kashmir, which means that really speaking, Article 370 had continued to operate even thereafter. Therefore, it would not be correct to postulate that Article 370 achieves its life and what is a temporary provision really assumes a state of permanence in the Indian constitutional fabric.
Lord, may I respect?
Because then there was no question of any constitutional orders being issued progressively from 1954 onwards or 1958 thereafter.
Refers to those decisions which were taken prior to its constitution. So to that limited extent, Constituent Assembly's approval was sought for. But subsequently, once the Constituent Assembly goes, whatever, my respectful...
But then where is the power to alter the constitution at all? If your argument is right, then once the Constituent Assembly in 1956-57 takes its decision, there is no power to change any provision of the constitution in relation to the state of Jammu and Kashmir.
I respectfully...
Which is contrary to what everyone accepted.
373 is only in respect of continuation of 370 or not. Now, they agree, Constituent Assembly agrees. Once it agrees that it has to be continued, then it becomes some kind of a permanent decision. Please permit me to reread that 373. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications from such date as he may specify, provided that recommendation of Constituent Assembly of State in clause D shall be necessary before President issues such a notification. So, idea is that you have to decide as a Constituent Assembly whether you want this relationship to continue or not. So, they took that decision